Good morning. The next case is People versus Christian, People versus Edwards, and People versus Hinton. This is a mini oral argument on the application, but with three defendants. So, Ms. Thomas, you will go first, and you have 15 minutes, and you can reserve if you like. And then Mr. Goodman with 10 minutes, and Ms. Owens for 5 minutes, and Mr. Tesner, you'll have 20 minutes after that. So, if I got anything wrong, just tell me, but otherwise, if you're ready to proceed, please do.
Good morning, Your Honor. Good morning, Chief Justices and Justices of the Michigan Supreme Court. My name is Kim Thomas. I'm here on behalf of Sequan Hinton. I'm going to focus my oral argument today on the Brady question and rely on my briefs or any further questions you have on the ineffective assistance of counsel that was also briefed on behalf of Mr. Hinton. In our briefs, we highlighted 5 factors that are commonly seen in this court and the U.S. Supreme Court when we look at the question of Brady impeachment evidence. They are all present in this case, and they all favor finding of materiality on behalf of Mr. Hinton. First, we asked, how important was this witness to the state's case? In this case, Jarrell Murphy, who the impeachment testimony is related to, was the state's key and only eyewitness in this matter. The cases ask whether the impeachment evidence would have supported the defense theory of the case, and it would have in this instance. Third, we look at whether the prosecution relied on this in closing testimony, and that, in fact, Jarrell Murphy was the key of their closing argument and their rebuttal. Fourth, we look to whether this impeachment goes to identification, and it does in this case, in addition to Mr. Murphy's other credibility. And fifth, we look at the cumulative impact on the case, which would have been significant here. In this case, what's at stake is that Jarrell Murphy was the purported sole eyewitness in the shooting of Robert Person. Murphy was not identified as present that night by any of the people verified on the scene, nor talked to by the responding police officers, and no one identified the victim as having been present with Murphy that night. Instead, Murphy surfaced a week later, purporting that he had information about the shooting and that he was with Persons for the hours before his death and during the shooting. When he spoke to police, that was on October 16th. It is that first statement to police, the transcribed statement of Jarrell Murphy to the police, that is the question of the Brady evidence in this case, that was not turned over to and was favorable to the defense. This is classic Brady material. I welcome questions from the court. Jarrell Murphy was the state's key eyewitness. The government has looked to what other evidence there might have been against Mr. Hinton. There was no other eyewitness testimony. There was no other physical evidence linking Mr. Hinton to this offense. What there was the testimony of Jarrell Murphy. The other evidence the state has pointed to is testimony, 4 or 5 things. Statement of Ashley Dye. Ashley Dye was definitely at the scene that night because her car was hit by a stray bullet. Ms. Dye was familiar with Mr. Hinton and testified that she saw perpetrators of the offense. She knew Hinton, and he was not among them. That does not support Mr. Hinton's conviction. The second was Monica McGee, who didn't testify with respect to Mr. Hinton. The third was Robert Moore. He was a jailhouse informant who allegedly spoke to Mr. Christian and Mr. Edwards in custody, and he testified about statements that one of the co-defendants stated about what Hinton was doing that night. And so that's the sole link from that evidence. Fourth is testimony from LaQuasha Blake, who was a former girlfriend of Mr. Hinton. He had professed his innocence to her the day after the offense, and I think about 10 months later in a phone call where he said, they can't find any evidence on me. They don't have any evidence to tie me to this offense. That's it. So the importance of Mr. Murphy's testimony cannot be understated in this case. Unlike this court's decision in Chenault, and unlike the U.S. Supreme Court and decision in Turner, where the suppressed evidence did not support the defense theory of the case, in this case it absolutely supported the defense theory. Also,
counsel, is that the key? Is that what matters most to materiality? I mean, I understand the critique of how the Court of Appeals looked at the question, but what's the right way to look at the question?
The right way to look at the question is to ask whether it undermines our confidence in the decision. And when thinking about that question, we try to understand what is the importance of this witness's testimony and how can we gauge that. and whether it would have mattered in the trial, right? And so these factors are a way for us to think about that consistently without reverting back to erroneous sufficiency of the evidence kind of analysis, so that we can, in fact, look at the importance of that materiality evidence. So, for example, we can look at what the prosecutor relied on in closing, where the prosecutor says, you can infer intent from what Mr. Murphy said. It was deliberate, as Mr. Murphy told you. So they're relying on Mr. Murphy's testimony for each element of the homicide case. The prosecutor in closing relied on Mr. Murphy's consistency over time. They said, Sergeant Gasper did a second interview with Murphy, who again said the same thing. But now we know, because we have that first testimony, that he did not in fact say the same thing, and he would have been impeached on that alleged consistency over time. They also relied on his consistency with known facts. What he told you made sense, the location of the shooting, the bicycle that they were walking, all of those things would have been impeached by the prior statement, which showed that he didn't have Mr. Person with a bicycle, that they potentially were sitting when they approached, and he was not walking at the time of that. Further, the prosecution relied heavily in closing on statements about a street light illuminating the faces of the alleged perpetrator. In fact, there's 12 mentions in closing and rebuttal of this street light illuminating the faces. And so this is a key of the government's identification testimony. And yet, in the suppressed statement, Mr. Murphy's asked whether he can see, and he says, not really, it was kind of dark, right? And so there's this stark contrast between what was emphasized in the prosecution's closing and what was in this statement.
Counsel, there's obviously different evidence against each of the three defendants in this case. It's not, do we think about this Brady question just for each defendant? Is that the right way for us to approach the question?
Yes and no, Your Honor. Yes, the court has to look at each case independently, right? This isn't a big glob of defendants, and so there was different information about each and different evidence with respect to each, and I think that's important for each individual person before the court to have that determination made. And the impeachment evidence in this case, Mr. Murphy was impeached with things, for example, going to memory. So he testified he had a photographic memory, and then he was impeached the next day when he couldn't remember what anybody had on the day before, right? So he was impeached as to that one aspect of his testimony, his memory. The first statement that was suppressed here goes to the question truly whether he was even present or not that night. It goes to whether he fabricated entirely. And that impeachment evidence is important to Mr. Hinton's case and also to the other defendants who were accused in this case. If there's nothing further, I'll save remaining time.
Yeah,
for
you may
rebuttal.
reserve, absolutely. Yep.
Good morning. May it please the court. Richard J. Goodman appearing on behalf of the defendant appellant, Joshun Edwards. The question before the court specifically is whether the withheld evidence was material. And certainly I agree with sister counsel that the Court of Appeals applied the wrong test, focusing on the sufficiency of the evidence and determining whether the withheld evidence was material. But even if the Court of Appeals was erroneous or wrong in focusing on that, of course, they did go through and review the other impeachment evidence that was used and admitted at trial. They did consider the other evidence against the admitted against the defendants, the other witnesses that testified. So I think the question for the court may be, well, did the Court of Appeals arrive at the right decision? Did they make the right decision? Maybe, but they got it there at the wrong map or the wrong direction. And there's a couple things that trouble me about that, two things that trouble me about that. The first one, most important, is the the concept, the argument in the reasoning of the Court of Appeals is that there was so much evidence, there was so much impeachment evidence that came in against Jarrell Murphy that it wouldn't have made a difference. I think the prosecutor notes that in his brief, this would have been just another layer of impeachment added onto the overwhelmingly great impeachment that was done by defense counsel at trial. And I think what that did was it ignored what I believe and what I submit to the court should be the primary and focus of the court, the primary principle in the test of whether or not the withheld evidence was material. And that is, what was the quality and the nature of the withheld evidence? In this case, I think the defendants can show, and certainly I submit to you, defense can show that the withheld evidence, that transcript of Jarrell Murphy's interview with the detective on October 16th, if they had had that available to them at trial, they could have destroyed Jarrell Murphy. Not just impeached him, but destroyed and thrown out his whole testimony. And they would have been able to show, based upon that transcript, that his story was a complete fabrication. And that's the reason why I brought this in today. This is an enlargement of the map that's contained on page 11 of my brief before argument on application. And of course, it shows the scene of the shooting, the Evergreen Regency Apartments on the east side of the downtown Flint, and it shows the Haskell Community Center where Jarrell Murphy started that afternoon playing basketball. And based upon this map and the bus schedules that are available from the Metropolitan Transit Authority that I picked up, the bus schedules would have shown that Jarrell Murphy could not have gone that distance based upon how he described there, getting the bus and then walking. He could not have arrived at the scene of the shooting until after the shooting had occurred at approximately 8:15. Now, this would have shown that Jarrell Murphy's story was a complete fabrication. And I think, and I submit to the court that this was impeachment. And yes, the defense attorneys did a lot of impeachment. There was a lot of areas they could have impeached him on. Certainly the lighting, his description of the lighting, the details. But introducing this evidence at trial would have added a whole new dimension of impeachment to the case. I think I submit to the court that this would have destroyed his testimony. And you could have thrown out, the defense counsel could have argued that none of his story was believable, the jury should not have believed or accepted anything in his story, anything he said. And I think it would have been significant to the point that the prosecution could not have rebutted it. They could not have rehabilitated Jarrell Murphy once this information had been introduced and used to impeach him at trial. I think the prosecution may note in his brief that, well, Murphy could have made a mistake. Witnesses make mistakes about time. I think even if they had a chance to bring this out and he had admitted, maybe I made a mistake at the time, maybe I took the bus a little earlier, I got on a different bus. Even if they had been able to do that, they could not have rehabilitated Murphy as a witness. And again, we know that Murphy was basically the only eyewitness. There was one other eyewitness, Ashley Dye, who could not identify Joshun Edwards. He only identified, I believe, the defendant Christian.
Counsel, why are you so emphatic that he couldn't be rehabilitated?
Because in order to get to, he testified that he went from the Haskell Center, and he got there at like 4:30, played basketball for a while, left the facility to get something, some kind of snack or something, ran into his sister, and his sister convinced him to go to visit her uncle at the Howard Estates. In order to get there, he had to get on 2 different buses. He had to take one bus from Haskell to the Downtown Transit Authority because all of the buses run from there. There's one bus that leaves the Transit Authority going on the route, one for the hour on the half hour. So if he had taken a bus to the Transit Authority downtown, he would have had to get on a totally different bus, and he could not have boarded that bus until the next scheduled bus left. So even if he got on it earlier, the earliest he could have gotten the bus out of the Transit Authority to go to the Howard Estates to visit the uncle would have been the 6:30 bus. The 6:30 bus would have put him at the Howard Estates somewhere around between 6:30 and 7:30. So even if it was 7 o'clock, he and his sister still had to walk the 1.8 miles to the Evergreen Regency Apartments.
So based on the timeline that was in the October 16th transcript, he couldn't have gotten there in time.
He couldn't have gotten there. If he said, oh, no, I got on the bus earlier at 6:30. Yeah, I told the detective 6:30 first, and then I thought about it, and no, I thought maybe it was earlier than 6:30. Well, even if it was earlier 6:30, to see what happens is at the Transit Authority, at 5:30, the buses start only leaving on the hour. So there's a bus that leaves at 5:30. Well, that bus, in order for him to take it, that bus had to go all the way to the Haskell Center, pass through the turnaround, and that takes an hour, and then it comes back. So even if he took an earlier bus, the earliest he would have gotten to the transit center would have been 6:30, and the next bus left to go to Howard Estates at 6:30, and that had to go out to the Howard Estates.
I appreciate the chart that was provided. Love a good chart that outlines all of this. I'm not seeing the bus question on the chart. So can you walk me through the time that he said that he got on the bus from the transcript on on October 16th, and then the November transcript? I'm just trying to understand.
Okay, well, just to kind of fill you in my appendix, I believe it's pages 42 through 45. I submitted the bus schedules and the routes.
No, I'm asking what the witness said from those various times. So we've got the October 16th transcript.
Mm-hmm.
We've got the summary of that. We've got the November transcript, and then we've got his testimony. Can you tell me briefly what he said was the time that he went to get on the bus? I know that at one point he said 6:30, and then he backed it up.
My understanding is, maybe counsel can correct me if I'm wrong, my understanding is that the only time he told the time of getting on the bus was in the first interview, the October 16th transcript, where he originally says, and the detective asks him, what time did you get on the bus? And he said, we got on the bus at 6:30. I don't think there ever came up. In the second interview, I don't think he was asked what time he came.
Did he testify at trial what time he got on the bus?
I don't think there was ever a statement about what time he got on the bus. There was a statement at trial that he went to play basketball at 4:30, and that was in the second interview. He did say that he went to the Haskell Community Center at 4:30 to play basketball. But there was never any time mentioned other than the October 16th transcript, the first interview, about what time they got on the bus. And there was no mention at trial or anywhere about taking 2 buses.
Was there mention? I guess the reason I'm asking these questions is because it seems that if it wasn't asked at trial and the witness wasn't testifying to something different, I'm not sure how that, if you had that information from the October 16th transcript, how that would have helped.
Well, we could have started the route at 6:30. The starting time of 6:30 would have placed him in this route between Haskell and
if he had said, yeah, I just had the time wrong, it must have been earlier than that.
even if he had the time wrong, he couldn't have gotten there. in time.
But you knew that at trial when he was at the rec center at 4:30. You could have done all of that at that point and laid that out at the trial. I'm just trying to understand why that statement of, that first statement that was in the suppressed transcript would have been that material at trial had you had that.
I think-
Couldn't the witness have been asked, you know, you were at the rec center at 4:30. There's no way that you could have gotten on these several buses and gotten to where you said that you were.
Yes, he could have been asked.
Okay.
He could have been asked.
Okay,
No, it's always possible to ask the question. No one picked up on it. But I think it was the 6:30 time that clued them in to the fact that this couldn't have been possible, couldn't have happened that way. And like I was saying, the quality of that impeachment would have made a big difference because, like I said, even if he had made a mistake and he could have started out a little earlier, he still would have been tied up right here.
Right, but, I'm
And
sorry,
then he
you
would've-
keep going back to that, but I don't understand. It seems like you didn't need this information where he said 6:30 if, no matter what he had said, based on his timing, he couldn't have gotten there. So I'm struggling to see why having the information of him saying in that first interview 6:30 is material. So I think we've gone back and forth.
Yeah,
Thank
well,
you.
I say that the materiality of it is in the quality of it, the strength of that impeachment evidence. And the reason I mentioned that a couple things. The reason I mentioned that he could have started earlier so it wouldn't have made a difference is that, number one, that we weren't provided, defense wasn't provided with that, so there really was no way in telling did he make a mistake because those questions could never be asked. But also because the way that the timeline works out and the fact that he had to walk all the way there, that even if you back it up a little and say, well, he got on the bus earlier.
Understood. Yeah, I think we've, I'm satisfied.
Okay.
I appreciate it.
I'm
Thank
just
you.
saying that I wanted to add that he also testified at trial all these other things he did when he got there to the Evergreen Regency. He met the person with his sister, and they went back to the person's house to get something to eat. He didn't have anything to eat, so they had to go to the party store. That's when they ran into a couple of the shooters, and there was a confrontation. They met the girl on the bike, and they walked around. Even if you back it up, the earliest he could have gotten to the Evergreen Regency was somewhere around 8 o'clock. And if the shooting occurred at 8:15, there's no way he could have done all of this other stuff according to his story.
Counsel, we've gone way over your time, but.
Oh, I'm sorry.
Yeah, no, that's okay. No, it's not. Justice Clement kept you up there, so.
I tried to stop several times. Yeah, my best
But
shot.
we're
Okay.
gonna have to let Ms. Owens have her time, so.
Okay, thank you.
Thank you very much. Yeah.
May it please the court, my name is Mary Owens, and I'm here on behalf of Kino Christian. I really don't have a whole lot to add because the issues have really been briefed very well by everyone. So, but there are a couple of comments that I definitely want to make in the 5 minutes that I've got. In the order directing the clerk to schedule oral argument, the court specifically referenced the case of People versus Chenault. So I went back, of course, and reread the case, and this bears completely on the issue of materiality. The court in Chenault found that the withheld evidence was not material because there were only minor discrepancies contained in the suppressed material from the other impeachment that went on, okay? What we're talking about in this case are not minor discrepancies. So I looked at some of the other cases, Strickler versus Green, Kiles versus Whitley, Weary versus Kane. Strickler versus Green says that suppressed evidence is material if it's sufficient to put the whole case in a completely different light. That's what undermining confidence in the verdict means. Kiles v. Whitley says if the suppressed evidence makes the case, the prosecution's case, significantly weaker. That's what it means to undermine confidence in the result. Weary versus Kane involved, like we have here, suppressed witness inconsistent statements, and the court didn't even order briefing in that case. It issued a peremptory order reversing, saying, yes, of course this is material, of course this is suppressed evidence. And the dissent in Weary versus Kane didn't object with that analysis. What they objected to was that the court, issued a peremptory order. They didn't allow for full briefing, which is what I think should happen in this case. I'm not even sure granting leave to appeal is necessary. So we have the Court of Appeals opinion conceding that the suppressed October 16th transcript raised discrepancies which were, and this is the court's own language, not entirely insignificant. But the Court of Appeals says, oh, there's so much other impeachment that went on that this not insignificant material that was suppressed wouldn't have made a difference. But it's not, the question is not whether there was other impeachment done by the trial attorneys, which there was. They impeached Gerald Murphy on a lot. The question is whether this suppressed transcript would have provided the most significant form of impeachment. And it's our contention that it was. This was the most significant tool that the defense did not have. And I'll tell you why. When you look at the prosecutor's closing argument, she goes on and on about all the evidence that was produced, and she goes on, and this confirms what Gerald Murphy said, and this confirms what Gerald Murphy said. So she's really relying on him and his testimony, his eyewitness testimony to be corroborated by everything else. But there's no way that his testimony would have been the focus of her closing argument, her star eyewitness, if this October 16th transcript had been available. And this Sergeant Gasper's summary really doesn't even come close to the value of this transcript. And as the Court of Appeals said, they're not entirely insignificant. So how do we know that for my client, Kino Christian, this would have been such a devastating tool? So I looked at Rob Wheaton's closing argument, okay? And he was the third defense attorney to give a closing. And he says, well, the other two attorneys that preceded me were being very kind to Gerald Murphy. But I'm not going to be so kind. And this is on page 32, I think it's trial volume 10. And he's talking about Gerald Murphy. Mr. Murphy, and I will be short because he's been dealt with very well at this point. He's saying, yeah, he's really been impeached. I'm not the gentleman that Mr. Grant is or Mr. Beauvais is. He's saying these other defense attorneys they don't want to call the kid a liar. I posit to you, I don't give him the benefit of the doubt. He was not there. He was force-fed this information, not by the police, but by somebody. Why? Maybe his relationship with the FOE is a little closer than he pretends or he testifies. FOE, remember, is the gang. So there, Rob Wheaton, my client's attorney, comes right out and says it. He's fabricated this whole thing. But he didn't have the October 16th transcript, which would have really solidified that defense. So I think I've come to the end of my 5 minutes. And unless there are questions, I'm going to sit down.
Thank you, counsel.
Thank you.
I should have rented an office here this week. May it please the court, Your Honors, Michael Tesner with the Genesee County Prosecutor's Office, appearing on behalf of the people, the appellee in this matter. I want to start out talking about the standard of review because I think that is incredibly significant in this case. This was brought on a motion for relief from judgment, and the trial court's decision is reviewed for abuse of discretion. So the trial court has discretion in matters in motions of this type, and findings of fact are reviewed for clear error, which is a highly deferential standard, and particularly when we're talking about what evidence was produced in the trial and what effect this new evidence might have. The judge sat through the trial. He viewed all the evidence. And then he went through the motion for relief from judgment and was able to compare the transcript that wasn't produced before trial with the information that was produced and the testimony, and to make factual findings in that regard. Now, from the Court of Appeals decision, the standard of review was the decision clearly erroneous? Or does it conflict with previous decisions of this court? And the court asked us to look and to consider Kino, but I think the trial court and the Court of Appeals both also went further and relied on Turner versus United States, which adds a little bit to the Brady analysis. It's still, what was said in Kino is still, the law under Brady. Did the prosecutor suppress evidence? It wasn't turned over. Number two, it was favorable to the accused in some way, as impeachment at the very least, because he did have some contradictory statements in that first interview. But then third, viewed in totality, is it material? And materiality, with regard to Turner, what they said about materiality is we must examine the trial record, evaluate the withheld evidence in the context of the entire record. And then in light of that examination, was there a reasonable probability that had the evidence been disclosed, the result of the proceeding would have been different? And I emphasize that because that's language that I didn't see in the previous cases, but examining it in the context of the entire record. And I also think it's significant because the defense is attacking what the trial court did and what the Court of Appeals did as merely looking at the sufficiency of the evidence. Well, they did look at the totality of the evidence because that's part of the test. But that's not all the Court of Appeals did. That's not all the trial court did. The Court of Appeals examined the trial record, reiterated the salient facts, looked at the arguments that were made by each counsel, including the prosecutor and all the defense, and particularly the impeachment arguments, both the impeachment of witnesses during testimony and also the arguments that were made in closing. And then it compared Murphy's trial testimony with the October 16th transcript, and paid particular attention to the cross-examination of Murphy by each counsel, and considered whether having that transcript would have made a difference in the outcome. Would it have affected Murphy's credibility so much that the jury wouldn't have believed him?
Because I have a question, and again,
Yes.
I just like to always kind of keep things simple. Why wasn't this just turned over? Like, what was the problem?
Well, Justice Bernstein, I've tried to find out what happened here. It appears that, well, the detective testified that she was not aware that there was a transcript of this interview. And I believe that the defense also FOIA'd the prosecutor file, and this was not in the prosecutor file. So the police did not turn this over to anybody. Now, either the detective was lying or she didn't realize that this was there. And that could happen. Let me explain this. Because, okay, in the Flint Police Department, and this is back in 2007, they were still using VCRs. There was a room separate from where they interview suspects where you could put a videotape in and record. Well, it's possible that the detective didn't know that. Let me back up. They also work in teams. On the homicide squads, they have teams of 2 detectives. It's possible that the detective, Ms. Gaspar, did not know that someone had put a tape in, did not know that, or didn't know that someone removed it and sent it to get it transcribed. I don't know. I mean, I wasn't there. There is no evidence in the record. All I know is that this was not turned over, and Detective Gaspar said that she did not, well, when she testified, she said there was no other transcript, just the transcript of the November interview. And that interview occurred in the prosecutor's office with the police and Murphy and his grandparents present. So I hope that answers your question.
It does, but I guess my concern is that, you know, ultimately, you know, the government has a lot more resources than defendants do. So isn't it kind of, in many situations, the responsibility of this court to kind of ensure that, you know, that these matters are handed over, and that, you know, before you go into trial, that the defense has all the materials that it needs to have?
I don't disagree with you, Justice Bernstein. Our practice in our office is to go through, in fact, and to invite the defense to go through the police file just to make sure they have all the evidence. We've had trouble with evidence being, you know, things that are in the police file being turned over late. Sometimes they're revealed during trial, and we try to, you know, keep that from happening by saying, you know, come and look at the police file. I mean, it's open. I mean, we have an open discovery policy.
But I guess my last question is, shouldn't there be a consequence, though?
Well, I guess I have two answers for that. One would be in terms of the Brady analysis, which is we are held responsible for the fact that it was not turned over. That's why we're here.
Right.
So that's true. I mean, if we knew what happened, would we need to address that as a matter of policy? Sure, we would, and we definitely would. We don't gain from the police not turning over evidence to us or to the defense. That's not our job. I mean, we take the pursuit of justice seriously.
Thank you. And you've answered my question. Thank you. I'll let you move on.
Okay. So now the Court of Appeals, after determining that the suppressed evidence would not have affected the outcome, then they went over the other evidence that was present against the various defendants. And I want to note, this was not a determination on the motion based on sufficiency of the evidence, but part of the review and the findings of the Court of Appeals that the rest of the evidence buttressed their determination that the absence of the suppressed transcript didn't affect the outcome. With regard to Kino Christian, Ashley Dye testified she knew Kino Christian. She was caught in the line of fire, and so she definitely was there. And she testified she saw Kino Christian as one of the three people she saw shooting. Okay? Number one, she said she saw three people shooting. She didn't say there wasn't a fourth person that she didn't see. Of course, how would she know? And as you all have heard, eyewitness identification, testimony during stressful events, people don't always get things right. That's why we talk about corroboration. That's why we talk about, people have inconsistencies internally and with other witnesses, because people see things differently. But she did see Kino Christian. And so who are the other people with him? That's where her testimony leaves us. Kino Christian, we had Robert Moore, who testified that Christian told him that all four of these defendants were involved in the shooting, and gave some details, and also that Joshun Edwards talked to him and told him that the four were involved. And both Christian and Edwards told Robert Moore, they tried to entice him to take care of their problem, which they saw to be Jarrell Murphy. They wanted him, when he got out of jail, to take care of Murphy. And there, you saw the facts in the briefs. Moore also testified that Christian told him that he and his nephew, Mike Hinton, encountered Jarrell Murphy and Robert Person, that Christian said he felt threatened by Person selling drugs in his territory and he planned to deal with him. And that's what happened. Christian also asked Moore, I said this. There's also against Kino Christian a surveillance video where he hides what turned out to be one of the weapons used in the shooting behind a gas station about a week after this murder. So there was video presented to the defense that Christian had possession of one of the weapons used. And then there was also and so the testimony against Edwards, Edwards told Robert Moore that he and the other three were involved and shot at Person. Moore testified that Edwards repeatedly solicited him to kill Murphy. According to Moore, Edwards offered a leather coat, which there was some testimony about that, and actually Moore did have a release. I'm sorry, not Moore. Moore. Moore did have a release from Edwards to take possession of his coat, which they valued at, he said was valued at about $1,000, and Moore said that was supposed to be a down payment for the murder. There was also a note that was, or a letter that was admitted related to the plan to take care of Murphy. And then there was also testimony from others that placed Edwards near this party store that Person was supposedly going to or visiting before he was shot. With regard to Mr. Hinton, again, there is the testimony from Robert Moore that his accomplices admitted to committing this murder and admitted that all four of them were involved. So, that was admitted, and so that's evidence against Mr. Hinton.
Can I interrupt here?
Yeah.
I think that you did a really good job laying all of this out in your briefing, and so I don't have any questions about these pieces. I guess what I think that this comes down to is, and what you're talking about, is all of these other pieces. But could the convictions have stood without Murphy? To me, it seems like Murphy was kind of the piece that pulled everything together. Without his testimony, would there have been convictions against these defendants?
Possibly, based on Robert Moore's testimony, because Robert Moore said, Kino Christian and Joshun Edwards told me they did this.
But if the jury
that's two.
discredited Murphy, wouldn't it call Moore's testimony into question? Wouldn't it be more likely that the jury would believe that Moore got his information from Christian's legal file, not from Christian? Isn't Murphy the thing that bolsters Moore? I'm sorry, Justice Clement.
Thanks. No, this is what I'm trying.
Well, conceptually, they bolster each other because they corroborate each other. But there's no evidence they got together and did this, so that's not part of the matter. For the jury not to believe Moore, if this additional transcript affected Jarrell Murphy's testimony and his credibility, there's two different ways to look at it. One would be they totally discredit him altogether. That may have made a difference. But if they thought he was lying and they didn't believe him at all, but I would submit that this transcript doesn't do that. What it does is it calls into question his ability to recall what occurred and in what order and at what times. And would that affect their view of his identification of these four? Because the identification testimony, the identification that he made in the October 16th interview, that was provided. That wasn't just from the transcript. That was written down and provided to the detective. So,
I'm sorry, from what? Which document are you referencing?
When Jarrell Murphy went in to talk to the police on October 16th, he wrote down a description of the four defendants, of the four people. And he also looked at a photo array and identified Mr. Hinton as one of the 4 shooters, or one of the 4 people that.
But in that transcript, this press transcript, my recollection is that he believed that he could identify the 2 that had an hour before had a conversation with him and the victim, but was unlikely, I can't remember the exact language, but didn't think that he would be able to identify the other 2 because it was dark, it was quick.
Well, I mean, if I'm misspeaking, I apologize, but my recollection was that he went in and he provided in writing, and maybe he did this at his second interview, maybe I'm getting them mixed up, but he identified by description.
But it matters, right? I mean, if it was the second interview, or it was the first interview that was not turned over, it matters. It matters what he said at his first interview that the defendants did not have, and what he said at the second interview. Would you concede that?
I agree with that.
Okay.
We're talking about what happened at that initial interview and whether it was known to the defense. But my impression was that he did describe the 4. He said it was dark and he might not be able to identify them, but he gave a description.
So let me ask you this. And the reason that I was asking about the timing from that first transcript and the questions that were asked at trial, maybe that alone doesn't get you there. But it seems like there's a lot of things. So when I look at Chenault, there was one thing, and the court said, no, you can overcome that. But when there's a lot of things, at what point is it too much? I mean, what's that line that we are looking for?
Well, the test is to look at various, I guess it's very case specific.
Right. I'm
So
asking here. So
in
we
this
know,
case?
yeah, we know what the test is.
I think-
What would have pushed us, what do you think pushes us past
I
that?
guess, and I apologize for using up a lot of time. That's why I was going through what the other evidence was, but you're right, I did put it in the brief.
Yeah, it was, I thought it was very well done in the brief, so.
Thank you. I think that makes a difference, because in Chenault, there wasn't so much corroboration of what, there wasn't so much corroboration of what the witness was saying. Well, I went through Chenault in my brief as well. There wasn't as much corroboration. In this case, there's quite a bit of things that, what are.
But that's only one piece of it. I mean, so in Chenault, there was one thing, I think, about, I'm trying to remember exactly what the witness had said, that she.
Well, she lied about, she said she didn't disclose one person, and she
knew
didn't
they
say
were.
there was a drug deal. I think there were some other things like that.
But that was, that could have been rehabilitated.
Right, but, well, I mean, here, reading that initial transcript, the transcript of that initial interview, it seemed to me that, number one, Murphy is not familiar with the area. He said that. And he lives on the north side of Flint, and the two areas don't generally mix. And one reason why is kind of the result here. I mean, there's a lot of gang activity, and you don't want to be in the wrong area. But he wasn't familiar with the area. He was trying to explain, and the detective kept asking, like, which direction and where, trying to get an idea of what he was saying in terms of, movements and what locations. And I mean, I think looking at that, he was confused as to a lot of the things. I mean, the thing about talking to the female, he at first says she wasn't there when the shooting occurred, and the detective asks again, or kind of leads him, and then he says, yeah, she might have been, or it was right after they talked. I found it confusing too, but these are differences in his recollection and in inconsistencies that they did cross-examine him about. They cross-examined him about the things in the subsequent interview as well. And I think what the Court of Appeals and the circuit court were trying to say was that he got details mixed up, clearly. But he was consistent with the identifications, and that, that was the import of his testimony, not like the fact that, number one, he witnessed it, that he was there, that he saw who was involved and he ran, and the identification of those people. And because that identification was corroborated, because of that, it did not affect the outcome. I mean, I think in this case, that's my argument.
Thank
Counsel,
you.
I have a quick follow-up to Justice Clement. So if we found that the suppressed evidence was in fact material to, say, one of the defendants, but it was more ambiguous as to the others, but there's concerns about honesty or whatever the concerns are as far as materiality, should this apply to all defendants because of the application to one of the defendants? We know we have different degrees of evidence that were presented in this case against all the different defendants.
I think Ms. Thomas was right when she said it depends, because if you're talking about did this affect Murphy's credibility to the extent that no one's going to believe the identifications? Well, that's one thing. If you decide that the Court of Appeals was wrong and that's correct, then, I think that does affect all three defendants. But if it has to do with the fact that two of these defendants admitted to someone else that they did this, and the other was only implicated by those two making their statement. And I would add that Hinton did say to his girlfriend, he was trying to make excuses like, they can't, my uncle Kino got me into this mess, but they're not going to be able to pin it on me. Well, how did his uncle get him into this mess if he didn't do it? Because Kino didn't say anything to the police. I don't see that. But at any rate, if there was evidence corroborating his identification of some of the defendants and not maybe one, I think it does make a difference. I think two of those defendants have not made out their case under a Brady violation. It's not material as to them because the undisclosed evidence would not have made a difference. But, it's possible that of multiple defendants, you might have a different result because of that.
Thank you.
Thank you, counsel.
Thank you.
Good morning. The standard for materiality is whether this undermines our confidence in the outcome. And I think the discussion today has helped us understand exactly how and why this undermines the confidence in the outcome. A few specific questions. Justice Clement, you had asked about the timeline. And so at trial, Mr. Murphy testified that he arrived on the scene at 4:30. That was the trial testimony.
Arrived where?
That he arrived at the uncle's house at 4:30. Okay. So the timeline matches to the homicide at 8-something. In the timeline, in the first statement, he says he left North Flint at 6:30, had a confrontation approximately 8 o'clock, and an hour to an hour and a half after that was the shooting. And then the summary incorrectly reflects that timeline and is more consistent with the evidence. Counsel spoke to, I would ask the court to look at the court's decision in Weary, the U.S. Supreme Court's decision. There are two things in there that are responsive. First, the court there cautioned that the state post-conviction court there improperly evaluated the materiality of each piece of evidence in isolation instead of looking cumulatively. So we might be able to pick apart one thing or another thing, but really here as the materiality inquiry, we need to look cumulatively at the impact of the impeachment on Mr. Murphy. And second, the court cautioned that state courts, in that case, erred by emphasizing reasons a juror might disregard the new evidence while ignoring reasons that they might not, right? Not giving full weight and credit to the potential impact of that impeachment evidence. And I would submit that that's incredibly important to think about when we're looking at the Court of Appeals decision in this case. Finally, with respect to, of course, the standard of review for constitutional errors de novo, and I would, we referenced in our brief the Caruso versus Warden. It's a Sixth Circuit opinion by Judge Kethledge. And in that case, the state engaged in a similar analysis. The state said it would support a finding beyond a reasonable doubt. And there, even in habeas, so under an incredibly deferential habeas standard of review, Judge Kethledge for the court reversed that and said, no, that's a sufficiency inquiry. And so that's not the appropriate standard for materiality. Unless there are additional questions. Okay, thank you.
Thank you very much. The case will be submitted. Thank you all.